to recent developments in class action standing requirements. I'm Ala Policastro, CLE advisor for the Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Pamela Prescott. Pamela is an attorney at Casaruni Law Group. She specializes in consumer rights litigation, including class actions for violations of the TCPA, FDCPA, and for unfair business practices and false advertising. Pamela also handles individual consumer cases involving inaccurate credit reporting, identity theft, and unfair debt collection. She has managed complex litigation in every federal district court in California and several other states. Pamela has been recognized multiple times by super lawyers as a rising star and was named to the National Trial Lawyers Top 40 Under 40 list. Pamela, we can't wait to hear what you have to share with us today.
Thank you so much for the introduction. And let's go ahead and get into the presentation. 1 second. Okay, so today we're going to talk about some recent developments in class action standing requirements. This has become a topic of interest following the Supreme Court's recent decision in 2021 called TransUnion versus Ramirez that we'll be going over today as well. And since that opinion came out, district court cases have been applying that ruling in terms of class action standing requirements. And just recently, I think it was April 30th of this year, the Supreme Court heard oral argument in a new case called Laboratory Corp of America versus Davis that might change standing in terms of class actions and when each class member has to have Article 3 standing in order to recover damages. So this presentation will kind of start with an overview of standing. I know it's probably a concept that's familiar to most of you, but I think it will help us as we get into the Supreme Court analysis, just to kind of have a refresh on that backdrop in terms of Article 3 standing, what's required to meet that threshold in federal court. And then we'll move into a discussion about TransUnion versus Ramirez. And then we'll finish with a discussion of the more recent Supreme Court case where there isn't a ruling just yet. But I took a look at the briefing and the recent oral argument transcript and have some thoughts there in terms of how the court might rule on that pending decision. So in terms of Article 3 standing, like I said, I think this is probably a concept that's familiar to most, but will help us as we kind of navigate this area of law. So as we all know, Article 3 standing requires that federal courts are deciding cases and controversies. This helps ensure that there's a separation of power by preventing courts from rendering decisions on cases that might not be ripe for a decision or a ruling, or that might touch on hypothetical issues. And so kind of in that same vein, Article 3 standing is a really important threshold jurisdictional requirement. It has to be maintained at all stages of the litigation. So that's something to keep in mind, unlike some other defenses that could potentially get waived at certain points in litigation. Article 3 standing can be raised at any time, and it can also be raised by the court itself. So with these Supreme Court decisions coming out in terms of TransUnion and the soon to be issued opinion in LabCorp, we see a lot of judges actually sua sponte raising the issue of Article 3 standing, even if it's not raised by the defendant. So this presents a unique hurdle, particularly in the class action arena, in terms of at all stages of litigation, ensuring that there's Article 3 standing and how that might implicate whether or not the class members are required to show Article 3 standing and at which stage, which we'll get into today. And kind of in that same thought is really just making sure that the court is not issuing an advisory opinion, that they're actually resolving a dispute where the parties have a personal stake in the outcome. In terms of maintaining Article 3 standing, a suit could technically become moot. One of the Supreme Court decisions that I note in the slide from 2013 was kind of an interesting legal issue before the Supreme Court in terms of whether or not the case had become moot. So Chafin versus Chafin centered around a child custody dispute in terms of where the child's country of residence was supposed to be. And so at one point, the child actually moved abroad. And so there was an argument that, okay, maybe this issue is moot. The residency has changed, but the Supreme Court said that basically a case only becomes moot when it's impossible for a court to grant any effectual relief to the prevailing party. So as long as the parties have a concrete interest, even if it's small, in the outcome of litigation, the case is not moot. So the court basically went on to say that each parent still maintained their position in terms of residency, and where the child was actually physically located did not moot the case for standing purposes. So that's kind of an interesting kind of analysis of that case was still deemed as right for rendering this a decision. And then another important consideration when thinking about Article 3 standing is that it's required to reach the merits of the case. So if a court doesn't have jurisdiction, they can't obviously rule on the underlying merits of the case. And so standing can be challenged if it's brought up by the defendant via Rule 12b-1 motion. And that's because it's part of the court's subject matter jurisdiction. And then also something to keep in mind is this isn't something that can be waived. So this isn't something that the parties could stipulate to, or that, like I mentioned earlier, the defendant could fail to challenge. It's something that can be raised by the court on its own. It has to be maintained at all stages of the litigation. And like I mentioned earlier, we're seeing a lot of courts actually raise it themselves and dismissing cases sua sponte for lack of standing. In terms of the burden of proof, so the party asserting federal jurisdiction bears the burden of proving its existence. So in most cases, that's going to fall on the plaintiff if they chose to initially file the underlying action in federal court. But an interesting wrinkle is in cases that are initially filed in state court that might have been removed to federal court, then that burden of proving standing would actually fall arguably on the defendant in that instance. So that's kind of an interesting procedural wrinkle there, but typically it would be the plaintiff that would have the burden of proving subject matter jurisdiction. And then the overall elements to satisfy Article 3 standing. So the first one that's usually contested is whether or not there's an injury in fact. The second element is that it has to be traceable to the challenged conduct of the defendant. And then the third element is that it's likely to be redressed by a favorable judicial decision. And so I cite here a case from the Ninth Circuit from 2017, Van Patten, that we'll kind of get into that highlights some interesting nuances in terms of standing. Something else to keep in mind when thinking about standing is it's not enough for the plaintiff to show standing as to one claim or one form of relief. The plaintiff actually has to have standing for each and every claim that they have brought forward and each form of relief that they seek. So it's a pretty high burden, especially if you have multiple claims and you might be seeking injunctive relief and damages, that you really need to show standing as to each of those claims and types of relief. And so it kind of touches on this general thought that if the plaintiff can't show generally that there was an injury in fact caused by the defendant, there's really nothing for the court to do in terms of issuing a remedy. So starting with the first element, the injury in fact requirement. So that really kind of has two subparts. The first is that there's a concrete and particularized injury. So the injury must be real, it must be a tangible harm. And courts, when kind of analyzing this, look to history and tradition in terms of guidance on what types of harms might lend itself to Article 3. And then the second prong is that the injury in fact must be actual and imminent. So it can't be speculative, it can't be hypothetical. And then in terms of typical types of harm that would meet the injury in fact requirement. So, one that's fairly easy to prove is financial loss or physical injury. So, typically those are traditionally, enough to meet the injury in fact requirement. So in the class action context, a lot of times you might have an unfair competition claim, and you're alleging that the plaintiff and the class were deceived and as a result paid more than they would have but for the deception. In the context of a data breach class action, one way to show financial loss is if, for example, class members had to pay for a crediting monitoring service, or if they lost access to their credit. So those are some ways that you can show financial loss. Where things get a little bit more complicated, especially in the class action context, is when we're talking about an intangible harm. So these types of harms need to have a close nexus to a common law analogous injury. So typical injuries that fall under an intangible harm would be a reputational harm, disclosure of private information, or intrusion upon seclusion. Um, Traditional harms could also be specified by the Constitution, for example, free speech. But something to keep in mind when we're looking at intangible harms is that a mere statutory violation alone does not always equal standing. And we'll really explore that here in a few minutes when we talk about the TransUnion opinion. But in terms of the Ninth Circuit case law prior to the Supreme Court's decision in TransUnion versus Ramirez, was the Van Patten case that was on my prior slide from the Ninth Circuit in 2017. So that centered around a TCPA revocation of consent text message violation. So the Ninth Circuit in Van Patten gave a nice analysis of a prior U.S. Supreme Court case. I think that at the time was the most recent in terms of this issue of statutory standing, or rather looking to a statutory violation to confer standing, and that was Spokio versus Robbins. So in kind of reaching its ultimate conclusion in Van Patten, the court explored Spokio's prior ruling, and in Spokio, basically the Supreme Court said that Article 3 standing requires a concrete injury, even in the context of a statutory violation, and reiterated the position that just because you have a statutory violation does not mean you have an injury in fact sufficient to have Article 3 standing. So ultimately, in the Van Patten case, the court found that two unsolicited text messages in violation of the TCPA was enough to have an injury in fact and satisfy Article 3 standing. Um, the court looked to the ultimate purpose of the TCPA in reaching that conclusion. So the court ultimately determined that unwanted telemarketing can be an invasion of privacy or a nuisance, and that Congress wanted to protect consumers from unwanted intrusion and nuisances of this kind, especially where the consumer didn't consent to receive the message. So in Van Patten, they found that the two text messages was enough. And we'll talk about it later too in terms of kind of that arena of TCPA standing, but at least as far as the Ninth Circuit and many other circuit courts, they found that one or two unwanted calls or text messages is generally enough to satisfy Article 3 standing. So moving on to the traceability element. So this just requires that the alleged injury is fairly traceable to the challenge conduct. So that really means that even if we have an injury, it must be actually caused by the defendant. So there must be a direct connection between the injury and the conduct that you're challenging. And then lastly is redressability, which is basically a favorable decision will redress the injury, can't be speculative. So the court's decision should ultimately provide you with some compensation or other form of relief for your alleged injury. So this brings us to the 2021 decision from the Supreme Court in TransUnion versus Ramirez. So in order to kind of analyze the court's ultimate holding, we're going to talk first about the underlying facts of the case, which are rather interesting. So we have a plaintiff, lives in California, Mr. Ramirez. He goes to a Nissan dealership to purchase a car jointly with his wife. And he ultimately is denied credit. He can't purchase the car in his name, but his wife is ultimately able to get the car in her name alone. And the reason why is because when Mr. Ramirez was at the dealership, they, as in most credit transactions, took a look at his credit report, and his name was actually flagged on a potential terrorist list. And so the underlying facts that gave rise to his name appearing on that list was that I think it was in 2002, TransUnion rolled out a new program for businesses called NameScreen, which sought to essentially flag individuals that were a threat to America's national security and to help businesses avoid doing transactions with those individuals. But the issue with name screen, at least as alleged in this case, and what potentially led to Mr. Ramirez being falsely flagged, is that TransUnion, the credit reporting agency that offered this additional add on product, basically just did a name matching. So they pulled the names off the Treasury Department's Office of Foreign Assets Control, which maintained this list of potential terrorists, and they just name matched with the credit report. So they didn't consider any other information other than the consumer's first and last name, which, as you can imagine, if you have the same name as someone that's on that list, that could result in you being flagged as a potential terrorist. It's interesting that at least at that time, I think there's been some changes made to this product, but at least as it stood in terms of when this injury happened to Mr. Ramirez, they weren't considering other pieces of identifying information like the consumer's social security number, address. It was really just a name match that resulted in this type of violation. So Mr. Ramirez, after being denied credit, calls up TransUnion, requests a copy of his credit report. TransUnion mails his credit file along with the statutorily required summary of rights. However, missing from his file on that first request was the erroneous terrorist alert. So that, I'm sure, created some confusion on the part of Mr. Ramirez. And then TransUnion actually sent him a second letter that did include that his name was flagged as a potential terrorist, but the second mailing didn't include a copy of the summary of rights. So Mr. Ramirez retained counsel. Eventually, that alert was removed from his credit file. But at least in terms of how this impacted Mr. Ramirez, he, I think, testified at trial that of the confusion and kind of distress that this caused. I think he also indicated that he canceled a planned trip to Mexico, probably out of fear of the implications of this being on his credit report. He was obviously denied credit in connection with the sale of the Nissan vehicle. And he eventually filed a class action lawsuit for three different violations of the Fair Credit Reporting Act. So the first one was the failure of TransUnion to follow reasonable procedures to ensure the accuracy of the information on the credit files of Mr. Ramirez and the other class members. The second violation was failure to provide all the information requested in TransUnion's first mailing, specifically that Mr. Ramirez was listed as a potential match on the terrorist list. And then the third bucket was in regards to that second mailing of TransUnion's failure to provide a summary of rights, which is required under the statute. So in the underlying district court case, the class was defined as all people in the United States to whom TransUnion sent a mailing during the period from January 1st, 2011 to July 26, 2011, that was similar in form to the second mailing that Mr. Ramirez received. So it would have been that you were flagged on the terrorist watch list, but that did not have the summary of rights. So the class was ultimately certified, um, and of importance and what will um, really come up in terms of exploring the Supreme Court's review is that the class was certified and it consisted of 8,185 members, including the named plaintiff, Mr. Ramirez, but only 1,853 of those class members had their credit reports sent to a third party. So as we can kind of see, that's a small fraction of the ultimate class that was certified that had their credit reports viewed or sent to a third party. So the district court found that all 8,185 members had Article 3 standing, and a jury found in favor of the plaintiffs. So, in terms of the underlying jury verdict, the jury awarded each class member about $984 in statutory damages and about $6,353 in punitive damages for a total award of over $60 million. And I think I touched on this earlier, but kind of relevant layer to the standing analysis is that at trial, Mr. Ramirez offered testimony about his experience at the Nissan dealership, in terms of how this violation impacted him, but there wasn't any evidence about the experience of the other members of the class. And then in terms of how they put forth this kind of class of individuals, the 1,853 members that had their credit reports sent to a third party. I believe that was stipulated between the parties at trial. So on appeal, the Ninth Circuit also held that all class members had standing to recover damages for all three violations of the FCRA. So, in reaching that decision, the Ninth Circuit recognized that the Ninth Circuit had previously acknowledged that only the representative plaintiff needed to satisfy standing on the motion to dismiss and class certification stages. So, this kind of touches on the issue of okay, so when do we actually need to show that the individuals in the class beyond the named plaintiff have standing? So, in analyzing the case of TransUnion versus Ramirez on appeal, the Ninth Circuit reiterated that based on prior cases, really only the named plaintiff needed to show standing through certification. So if we're thinking about a class action and the procedural mechanisms, typically most class actions are faced with a motion to dismiss. So at that phase, the Ninth Circuit was saying that only the named plaintiff needed to demonstrate standing. And even at the class certification stage, again, it was only the named plaintiff that needed to demonstrate Article 3 standing. And it was also acknowledged that this was the same for seeking injunctive relief. So it's kind of an interesting distinction there that really injunctive relief is looked at quite differently than a class seeking damages. So the Ninth Circuit acknowledged that it was a matter of first impression to determine which parties, in terms of the named plaintiff and the absent class members, had to demonstrate standing in order to recover monetary damages. So, like I said, the Ninth Circuit ultimately said that all of those 8,185 members had demonstrated standing and were entitled to recover monetary damages. And in terms of kind of the analysis there, the Ninth Circuit said that those 8,185 members had standing on each of the claims because of TransUnion's reckless handling of the information that it obtained from the name search in terms of flagging people on the terrorist watch list, and that it exposed every class member to a real risk of harm that their concrete privacy, reputational, and informational interests protected by the FCRA would be violated. And then in terms of the reasonable procedure claim, the Ninth Circuit said that a violation of statutory rights constituted a concrete injury under Spokio. So that was kind of how the Ninth Circuit concluded that everyone had standing and ultimately affirmed that part of the district court judgment. But the Ninth Circuit did, I think, reduce the punitive damages to 3,936, which reduced the total award to about 40 million. So turning to what the Supreme Court actually decided in TransUnion versus Ramirez. So the question before the Supreme Court was whether these 8,185 class members have Article 3 standing as to their three claims. So as we know, the Ninth Circuit found the answer to that question to be yes. And it's interesting too, even the way that this question is framed, is that it's as to their three claims. So as we talked about earlier, the burden of proving standing isn't just to one claim. You really have to prove it as to each individual claim. And so those were all different parts of the FCRA that were claimed to be violated. And so the Supreme Court was addressing those three buckets of statutory violations in terms of analyzing whether all of these class members had standing. So in terms of who wrote the majority opinion, just to give a little bit of context for this ruling, which came out on June 25th, 2021, the majority opinion was issued by Justice Kavanaugh, and it was a 5-4 decision with 2 dissents. So it was a pretty close call in terms of the ultimate decision. And the Supreme Court really went into a very detailed overview of Article 3 standing, specifically in terms of what's required to show concrete harm under the injury in fact requirement. Um, and so the court first looked at that first bucket of violations in terms of the failure to follow reasonable procedures to ensure the accuracy of the reporting. And the Supreme Court ultimately held that only that group of 1,853 class members who actually had their credit report sent to a third party suffered a concrete injury in fact under Article 3. So, in arriving at that conclusion, the Supreme Court acknowledged that those class members that actually had their credit report published suffered an injury because the harm had a close relationship to a traditionally recognized basis for a lawsuit in American courts, namely the reputational harm associated with the tort of defamation. Um, so the court then went on to say that basically that other bucket of individuals, I think it would have been 6,332 that didn't have their credit report disseminated to a third party, didn't suffer concrete harm because, and this is kind of an interesting analogy that the Supreme Court gave that I highlighted here, but the Supreme Court said that in cases such as these, where allegedly inaccurate or misleading information sits in a company database, the plaintiff's harm is roughly the same, legally speaking, as if someone wrote a defamatory letter and then stored it in her desk drawer. A letter that is not sent does not harm anyone, no matter how insulting the letter is. So the Supreme Court really kind of teased out this idea that we started to see in Spokio, that basically a statutory violation is different and apart from being able to show an injury in fact. And just because you have a statutory violation doesn't mean that you've demonstrated your burden of showing that there is Article 3 standing. And the Supreme Court noted that there's a huge difference between a plaintiff's statutory cause of action to sue a defendant and a defendant's violation of federal law. So here, the violation of the FCRA and the plaintiff suffering a concrete harm because of that violation. And so the Supreme Court said that um, basically that Congress might create these laws and requirements in terms of obligations, particularly here, the obligation of a CRA. But under Article 3, an injury in law is not an injury in fact. And only those individuals that have been concretely harmed by the statutory violation may sue the private defendant over that violation in court. And the Supreme Court went on to note that basically um, violations that don't cause any harm, are merely a legal infraction. So a legal infraction without harm is not enough to bring a case in court. And so, as you can imagine, in terms of the dissenting opinions, um, Justice Thompson authored one of the dissenting opinions and basically said that historically a private right has been enough to establish an injury in fact. And Justice Kagan similarly said that if Congress is allowing plaintiffs to bring their claims for the violation of the FCRA, um, through the statutory requirements, but here we're preventing those plaintiffs from actually asserting those violations because they haven't met the harm threshold. So it kind of begs the question of, okay, if we have a violation of a federal law, um, but we're limiting in terms of who can bring that based on the type of harm, does it make those statutes have less teeth and we'll get to kind of analyzing informational injury, but it kind of seems to be at tension with the fact that there is an underlying violation, just that the harm is not recognized as to be sufficient to confer Article 3 standing. And before we move on to the second and third violation, which were analyzed by the court together, it's interesting to see that if we look at this group, and I'll kind of go back a little bit just so we can see the visual, but this group of 1,853 members that did have their credit report sent to a third party, the Supreme Court basically said, we have no issue finding that those persons were harmed and that they've satisfied Article 3 standing. And they analyze like I mentioned earlier, the tort of defamation, but really focused on in terms of finding the other 6,000 or so individuals as not being sufficiently harmed, is that there's a publication requirement um, under that common law claim. And so the Supreme Court said that the violations here had a close enough relationship to the harm associated with defamation, and that potentially flagging individuals as terrorists was enough to be akin to subjecting someone to hatred, contempt, or ridicule, which is required, and touches on the injury that would flow from a defamation type of harm. And that the Supreme Court also noted that we don't require an exact duplicate, meaning that there just needs to be a close relationship with the harm that's traditionally recognized as providing a basis for a lawsuit in American courts, but it doesn't have to be exact. So in looking at that opinion, I thought that was kind of an interesting point on this, that you just really have to get close to that traditional harm, but it doesn't have to be exact. And here, flagging someone as a potential terrorist was enough, and bore a close enough relationship to be defamatory as if they were labeled as a terrorist. And that the Supreme Court found that was enough, but really was focused on this publication requirement. And went on to note that these 6,332 class members were missing that publication element. And so we see that in this quote, that, with the analogy of the desk drawer, that just because it's a violation, if no one saw it, doesn't mean you were harmed, at least from the Supreme Court's perspective. So And they expressly said that just the presence of an inaccuracy on an internal credit file that's not disclosed to anyone doesn't cause a concrete harm. And they also pointed out too, in terms of, because this case, obviously went to trial, there was evidence put forth at trial, and the Supreme Court really acknowledges that the plaintiffs didn't put forth any evidence that the class members were independently harmed, aside from Mr. Ramirez testifying about his own individual harm. Um, and, the Supreme Court even hinted that there wasn't even any evidence put forward that the class members suffered emotional injury, or that they even knew that these violations occurred. Seemed to be something that the Supreme Court drilled down on, that there really just wasn't enough evidence to show that the other group of individuals, apart from the publication issue, were aware of the violation and were harmed in any way. When I was initially looking at this, I thought, well, maybe there could be an argument for refraining from utilizing your credit. Maybe you didn't apply for credit, but I think the Supreme Court kind of closed that door by saying that there wasn't even any evidence that these individuals knew it was on their credit report, which would kind of foreclose any argument that they were refraining from utilizing their credit, or that they were distressed by this information, because if they weren't aware of it, in the Supreme Court's view, it really lends itself to showing that there really wasn't any harm. So as for the second and third violations of the FCRA, so the Supreme Court really analyzed these together. And this was the failure to provide all the information requested, and the failure to provide the summary of rights. And the Supreme Court found that none of the class members, aside from Mr. Ramirez, suffered a concrete harm. Um, so that's kind of interesting in terms of how this harm was framed. And really, the Supreme Court framed it as an informational injury. And so this type of intangible harm, the Supreme Court said, basically, if there's no downstream consequence from this informational injury, that's not enough to satisfy Article 3 standing. Um, so it kind of, I think, clarified this issue of an informational injury, that's not even enough. So you really have to take that extra step and say that it caused some type of downstream consequence or adverse effect. And I pulled a case that what we can talk about in a couple minutes of how courts have really defined the contours of informational injuries, particularly in the class action context post Ramirez, because traditionally, if we have an informational injury, for example, the failure to provide the summary of rights, that type of violation lends itself nicely for a lot of other reasons to a class, because you have um, the same consumers receiving the same letter with the same violation and the same language. It was probably a form letter. But here the Supreme Court is really drilling down and saying that the informational injury is not enough. You need to allege some other harm that flowed from that informational injury, which makes things a little more difficult in the class context. So, some takeaways from TransUnion. The big one was that every class member has to have Article 3 standing to recover damages at trial. So that was kind of a big one, um, that came from this opinion, is that was clarified, but also that the mere risk of future harm can't confer Article 3 standing. So a lot of circuit courts and district courts were looking to Spokio to say that we have a statutory violation. It's exposing consumers to a risk of harm, or the named plaintiff to a future risk of harm. But the Supreme Court said that's not enough, that's insufficient to confer standing. So that kind of clarified that in the context of really teasing out what's required beyond a statutory violation to show that they're standing. So as we kind of talked about, there's these three buckets of injuries, and it kind of lends a question of, okay, well, what types of harm are sufficiently concrete under TransUnion? So as I noted, we have that verbiage from the Supreme Court saying that you have to show downstream consequences in the context of an informational injury, and that the Supreme Court really highlighted that there was no showing that the alleged information, so the failure to provide the summary of rights or the failure to include the terrorist list, the erroneous flag on the terrorist list, hindered their ability, and especially because those credit reports weren't disseminated to a third party, with regard to the kind of 6,000 individuals in the class. Um, so, it's interesting in terms of the informational injuries. I took a look at a couple cases that have kind of grappled with this concept post Ramirez. One of them was Bowen versus Select Portfolio Servicing Inc. From the District Court of Massachusetts from July 26, 2024. So that was a class action that was brought for violations of RESPA for failure to provide recordings in response to a qualified written request or a QWR letter. And in that case, the plaintiffs actually allege that they were injured because they didn't receive the recordings and the transcripts of the phone calls that they requested. But the court said, no, that's not sufficient under TransUnion. That's purely an informational injury that caused no adverse effects. So they didn't take that extra step and explain why the withholding of those recordings caused an injury. So that's kind of interesting in terms of those types of violations where you might have a statutory violation, but you haven't sufficiently proven how that violation actually caused a concrete injury. Another case, this one's from the Eastern District of California before Judge Thurston, and it's Manzarez versus Madera Collection Services. So this was interesting. It was a class action lawsuit filed for violations of the FDCPA, because basically the punitive class and plaintiff were receiving undated collection letters, so they couldn't determine the charge off amount, or the date that the letter was sent because they were undated. And the defendant filed a motion to dismiss, and the court, sua sponte, analyzed Article 3 standing and noted that it wasn't raised by the defendant, but the court has an obligation to ensure that there's standing. And ultimately, the court dismissed that case, finding that essentially that the FTCPA doesn't confer the right of an informational injury, and that the plaintiff hadn't made a concrete showing that they were actually harmed. And I thought this was kind of an interesting opinion only because the plaintiff did, at least in arguably in my view, did allege the downstream consequences of not having a data collection letter. The plaintiff said that they were misled as to the status of the debt, that the letters, they questioned the legitimacy of the letters because they didn't have the date, that it prevented them from making informed decisions regarding the debt, because they couldn't determine how long they had to respond to the letter. So, they did put forth at least a showing of some related consequences that arguably everyone in the class would have suffered in terms of having undated debt collection letter. But Judge Thurston from the Eastern District didn't think that that was sufficiently concrete. And she even noted that, that these were kind of bare bone allegations that weren't plausible, and that she didn't think that there was Article 3 standing. So, with decisions like that, it really increases the burden on plaintiffs to demonstrate the type of harm flowing from an informational injury. So something to keep in mind. In terms of intangible harms, so again, we have the TCPA types of class actions, that lend themselves to an invasion of privacy. And most circuit courts are on board now that, like I said before, one or two text messages or unwanted calls are enough. And then, of course, we have tangible harms, which still remain alive and well in terms of showing Article 3 standing. And something important to note too, that the degree of the monetary harm is not generally considered when thinking about Article 3 standing. So I think some courts in the Ninth Circuit have even said a penny is enough. So it's really the type of harm that's being scrutinized, not necessarily the degree, which is kind of an interesting distinction there when looking at what types of harms are sufficient. And a recent case that actually just came out from Judge Vera in the Central District of California examined just this in terms of tangible harms in the class action context. There, it's Leon versus Honda Motor Co. And in that case, there was an alleged defect, I guess, on sensors for retractable doors that were causing the vehicles to be unsafe and causing injuries to consumers because they weren't closing properly. And so in that case, Honda argued that there's no harm because the plaintiffs got what they bargained for. The vehicles, you can't just allege that there's a better way to design a vehicle. There's no harm, there's no economic injury. Um, and Judge Vera acknowledged that no, in the Ninth Circuit, we've consistently held that that where a plaintiff alleges that they wouldn't have purchased the property or they would have paid less, um, that's enough to show an injury in fact. And then, kind of in that same vein, the court also found that the plaintiffs alleged an economic injury because of the diminished economic value. So, the car is worth less because of this defect. And so, the case was able to proceed. So that was kind of an interesting reaffirming of some of these principles that might lend themselves nicely to particularly an unfair competition type of class action. And then we have this kind of last bucket that I mentioned earlier about injunctive relief. And so, it still stands that essentially, in terms of seeking injunctive relief, that only the named plaintiff has to show standing. So, in terms of kind of deciding which types of cases to file in federal court, maybe it might make sense to only seek to certify an injunctive relief class, because you wouldn't have to show standing as to individual class members, just the named plaintiff. Um, so it's interesting because the Supreme Court kind of left open this big question in TransUnion, which is whether every class member has to demonstrate standing before a court certifies a class. So it's important to remember that in TransUnion, we had a trial, we had a judgment, and the court was determining whether or not the class members had standing as to those three claims to recover damages. Here, there was still no clarity, at least from TransUnion, on whether that would apply before certification. So historically, many courts agreed that TransUnion, and even prior to that, didn't require proof of standing as to each class member prior to certification. So as long as the named plaintiff had standing, which we saw the Ninth Circuit in the underlying of Ninth Circuit opinion in TransUnion acknowledged that before certification, and at the pleading stage, really we're only looking at whether the named plaintiff has standing. And some courts have even said that really it's only the remedial phase at trial. So up until that point, you don't have to show that each individual class member has standing. So that kind of lent nicely to the decision that's presently before the Supreme Court, which is Lab Corp of America versus Davis. So the underlying facts of this case are that the plaintiffs are alleging that LabCorp discriminated against them as it relates to visually impaired individuals because of these touchscreen kiosks that were implemented in LabCorp's businesses, which weren't suitable for the visually impaired. So the plaintiff, Mrs. Vargas, in the underlying um, district court case, alleged that she, or I think he rather, went to a LabCorp facility. He tried to check in. He couldn't use the kiosk because he's visually impaired, and that resulted in him having to wait for assistance and being discriminated against, because he couldn't properly access that kiosk in order to check himself in to receive services. And so the underlying violations were a host of statutory violations under federal and state law. And at the district court level, um, Judge O'Guin from the Central District of California ended up certifying two classes. So a California class, damages class, and then a nationwide class. And so it's interesting because it kind of became relevant to the appeal in terms of what the justices asked at the oral argument. But there's kind of this interesting procedural history on the ultimate, I guess, operable order of the certified class. And I'll kind of break that down. But basically, in May of 2022, the court certified the class, but then amended that order in June. And so it became relevant to the Ninth Circuit's ruling, and as well as some concerns by the Supreme Court of whether there was actually jurisdiction, because the defendant LabCorp only technically appealed the May 2022 order, which was superseded and amended by the June order. Um, and we'll kind of get into that too, but it is an interesting kind of procedural wrinkle that could ultimately prevent the Supreme Court from reaching the merits. So at the Ninth Circuit level, the Ninth Circuit ultimately did find that that there was Article 3 standing, and kind of explored the ultimate violations in the disability discrimination context. And the Ninth Circuit said that it's not necessary for standing purposes, that the plaintiff was completely precluded from entering or using the facility, rather that they were denied a full and equal enjoyment of the facility. So they found that was sufficient here, and that there was an allegation that there wasn't proper access to fully communicate using the kiosk because of the obstacles that were presented to the visually impaired that couldn't utilize those kiosks. So they found that there was standing ultimately at the Ninth Circuit level. But the Ninth Circuit did ultimately address this issue, and basically pointed out that LabCorp only appealed the May order. It didn't amend its appeal, and it didn't attempt to refile or include the June order. So the Ninth Circuit did kind of point that out, even though it went through the ultimate standing analysis. It did note that perhaps the wrong order was ultimately at issue in the appeal, but nonetheless was still able to issue a decision. So that kind of leads us to what the question presented before the Supreme Court is now, which is exactly where TransUnion left off, which is whether a court can certify a class under 23b3 when only some members of the proposed class lack any Article 3 injury. And the argument was based on the fact that the underlying classes that were certified included individuals that may not have wanted to use the kiosk. So some of those individuals may not have suffered harm, and they were part of the ultimate class, but the district court was able to certify the class. And it's also interesting because standing wasn't actually raised at the district court level in terms of opposing class certification. So the Supreme Court just heard oral arguments a few weeks ago. If you want to listen to it, it's available. It's pretty interesting because the attorney for LabCorp kind of begins his argument framing some of the issues as really whether Article 3 prevents a district court from certifying a class that contains uninjured class members. And the justices immediately jump in and want to talk about this procedural issue. I think it was Justice Thomas, like a minute into the oral argument, says that there's a number of orders, and it seems like the only one that's before us is this May order, which is now inoperative. So why do we have jurisdiction? And they spent quite a bit of time going back and forth on this jurisdictional issue. And Justice Sotomayor also chimed in and said that wouldn't this be an advisory opinion if we were to rule on this issue because the May order is not inoperative. So it's kind of interesting that was the focus, at least of the first half of oral argument, rather than getting to the ultimate heart of the question. And it will be interesting to see if the Supreme Court actually reaches this issue. Um, a lot of commentators have said maybe not, but others have said that the Supreme Court was likely aware of this issue based on the Ninth Circuit's ruling, and that there's an interest to resolve the circuit court split in terms of when you have to demonstrate Article 3 standing and if you have to prove it at certification for a damages class. So, maybe they'll get past that jurisdictional issue and actually reach the merits. But some people say that it looks like they might use that to kind of punt getting to the merits altogether. So an interesting procedural wrinkle that perhaps might defer the Supreme Court from resolving the circuit court split. And then the other issue too is kind of the justice's questioning of LabCorp's position. And so I think Justice Sotomayor was part of the dissenting opinion in TransUnion, and she points out that class actions are fluid, and this is a quote from the oral argument transcript, and that it's not until the judgment's entered that you actually have to determine whether there's a way to identify who's been injured and who's been not. So she was really framing um, separating out potentially uninjured members from a certified class as really being a Rule 23 issue at trial and not necessarily a jurisdictional issue. And I think she even said that we have jurisdiction at oral argument. She's like, we have some named plaintiffs that have been harmed, that are part of the class, and the issue is do we have a way to identify and differentiate between those that were harmed and those that were not in terms of ultimately awarding damages at trial. And that's really a Rule 23 issue. So it's to be said kind of how the Supreme Court will ultimately rule. If they do ultimately reach the merits, it could provide some uniformity. Certainly if they answer the question in the affirmative, or I guess in the negative, that you can't certify a class unless you all of the class members showing that they were injured, that could potentially increase the burden on plaintiffs. It could certainly make it much more difficult to move for class certification in terms of how you're defining your class. So it will be interesting what they ultimately decide, and if they actually reach that issue, given kind of the procedural wrinkle that's before them. And I think they're supposed to issue an opinion before the end of the term. So probably in the next couple months. We'll definitely be keeping an eye out for that and seeing how it continues to define the contours of this ever-changing area of law. And I think I have a couple minutes for some questions, if there are any. Let's see if I can jump out of here. So let me see if there's any questions that we have. I don't think anyone asked any questions, actually. If anyone wants, I know I kind of listed some cases that might not have been in the slides. So if you want those citations or you want any more information on this topic, you can definitely email me. I think I put my email on the last slide. Always happy to chat about these issues and provide you with those citations and any other legal questions you might have on this issue. I think the big takeaway is, at least for now, in the Ninth Circuit, certainly you don't have to establish individual damages as to all class members at certification, that it really is reserved for trial and when you get to the damages award phase. So until the Supreme Court, if and when they make this ruling, if they're even able to, I don't know that it's going to impact the timing of kind of establishing Article 3 standing as to absent class members. And another thing that I think I didn't touch on that's relevant to this is that, as the burden on plaintiffs gets higher in terms of establishing standing, particularly in the consumer class action arena, that's going to probably drive many cases to state court. I do think it's interesting, if there are questions on standing, and if you have a statutory violation, but you might not be sure that they're standing, filing it in state court, and then waiting for the defendant to remove. And then, I mean, at that point, the defendant's the one seeking federal jurisdiction, and the burden's on them to prove standing. And then at least you could get remanded back down to state court versus potentially litigating a case for a year and court sua sponte raising the issue of Article 3 standing and dismissing the case. So there's always that kind of decision to be made in terms of where to initially file the case. So state court's always an option there. But yeah, that's the end. I appreciate everyone spending this hour with me. And like I said, if you have any questions, feel free to reach out. And thank you to the Beverly Hills Bar Association for letting me speak on this topic.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.